Hello, my name is Barry Arrington. I am the Chief Legal Counsel for the National Association for Gun Rights, and we have major breaking news. We have been waiting for the Supreme Court's decision in the Rahimi case since oral argument last November, and there's been a lot of speculation about what the Supreme Court was going to do in this case. Were they going to use this as a vehicle to clarify Bruen? Were they going to narrow Bruen? Were they going to expand Bruen? What was the court going to do with this case? We have the answer to that question today. The bottom line is Rahimi is a little bit of a nothing burger. The court really didn't do much. So let me go into it and give you the background of what the Rahimi case is all about, what the court did, and what it means for the Second Amendment. So what is the Rahimi case all about? There is a federal statute, and it's 922G8 of Title 18, which basically makes it a crime to carry a weapon while you're subject to a domestic violence restraining order. Now, this Rahimi character, he's a bad actor, and he had shot at or in the direction of his girlfriend. She got a restraining order against him, and so he was subject to one of these domestic violence restraining orders. But while he was subject to that, he kept on carrying his weapons, and he actually abused his Second Amendment rights and shot up a house and shot up a neighborhood. One of the crimes, many crimes with which he was charged as a result of that, was carrying a weapon in violation of this statute. He was convicted. Then it went all the way up to the Fifth Circuit Court of Appeals, which is the circuit court that has jurisdiction over Texas, where Mr. Rahimi lived. The Fifth Circuit held that there is no sufficiently similar founding-era analog to a disarmament under a domestic violence restraining order and struck the statute down 100%, completely vacated it. And the government obviously appealed that decision to the Supreme Court. The Supreme Court granted certiorari. Argument was in November. The decision came out today. What did the court hold? The court reversed the Fifth Circuit. The court said the Fifth Circuit got it wrong. How did the Fifth Circuit get it wrong? Well, it said that there are some laws from the founding era that are sufficiently analogous to this restraining order law to allow this to stand under the Second Amendment. And so what are those analogies? Well, there were two that the court relied upon. One was the surety laws from the founding era, and one was the going armed laws from the founding era. Now, what are those? The surety law was if someone was held to be a credible threat of violence to someone, they had to post a bond, for example. And if they went forward and actually hurt that person, they would forfeit that bond. It was a way of giving them an incentive not to go forward and hurt people. The other one was the going armed. Now, going armed, that sounds like, well, can they just otherwise prohibit going armed? Isn't that against Bruen? So that is not what it means. Going armed is kind of a term of art. It doesn't mean going armed literally. It means going armed with dangerous and unusual weapons in such a way that it terrorizes the community. There was a common law offense called affray. And going armed is a subset of this affray offense. And so if you run around with dangerous and unusual weapons and you terrorize people, well, that was against the law at the founding era. And the court found that these affray laws, these going armed laws, were sufficiently analogous. And so what was the overall principle that the court landed upon in terms of application of the Second Amendment? Well, the court said that under these analogies, if there is a finding by a court that a particular person is a credible threat to the physical safety of another person under this statute, that is sufficient to disarm that person, and it does not violate the Second Amendment. That's all the court held. It did not retreat from Bruen. It did not break any new ground. It basically applied Bruen, and basically the only thing that it disagreed with the Fifth Circuit was whether these laws were sufficiently analogous. So, what does this mean for the Second Amendment going forward? So, frankly, it doesn't really put us in much of a different position than we were yesterday. There's a lot of litigation around the country concerning the parameters of Bruen and the text stage of Bruen and the history and tradition stage of Bruen and how those are applied. With respect to the first issue, the text issue, Rahimi was utterly silent. It said, yeah, Bruen has two steps, text and history. Text, no one disputes that he's been disarmed, and that would be implicated by the plain text of the Second Amendment, disarming someone. So the court dealt with the text issue in just a couple of sentences. And with respect to the history and tradition issue, it said, yeah, the next step is, yes, it's covered by the plain text. The government has to produce analogies from the founding era to justify its regulation, and the government has, in fact, produced those analogies in these surety laws and going armed laws, and therefore this particular statute does not violate on its face the Second Amendment. Now that's another area where Rahimi is extremely narrow. The Rahimi case was what's called a facial challenge. There are two ways you can challenge a statute under the Constitution. You can say that it is facially invalid, which means that it is not, there's no way that this particular statute can ever be applied constitutionally, or the vast sweep of the cases that it covers cannot be applied constitutionally. That is a very tough standard to meet. It is a difficult standard to say this statute can never be applied constitutionally. And the courts have generally disfavored facial challenges. The other type of challenge under the Constitution is what's called an as-applied challenge. Now, in an as-applied challenge, the plaintiff comes up and says, well, the statute may be generally constitutional, but the way it got applied to me in this particular case was unconstitutional for various reasons. And the court specifically said that we're only deciding that this statute, 922G8, is not invalid facially, that there may be some areas in which it is appropriate to apply it. And in particular, this case, it was appropriate to apply it to Mr. Rahimi. The court said, we're not closing the door to what's called an as-applied challenge. In a different case, under this same statute, if someone comes in and says, well, I didn't have notice, or it wasn't fair to hold me as a credible threat, there was no evidence that I was a credible threat, and therefore the order was invalid. I'm speculating about what a plaintiff might say in these sorts of situations. The court could very well say that as applied in a particular case, the statute is unconstitutional. Court did not close the door to that. So what is the news about Rahimi? Well, the main news about Rahimi is that there's no news. It didn't break new ground. It didn't cover any new issues. It's basically is a straightforward application of the Bruen case, text stage and the history and tradition stage. So in that sense, it's good news for the Second Amendment community because Bruen was a tremendous help. It outlawed the so-called interest balancing where judges said, well, yeah, this affects your Second Amendment rights, but we think it's a good idea, so we're going to let the law stand. And basically making a policy decision in favor of the government and opposed to people trying to exercise their Second Amendment rights. The court did not retreat on that at all. The so-called interest balancing or tiers of scrutiny or intermediate scrutiny still invalid under the Second Amendment. Now, the three liberal justices basically agreed with the result of this case, although they said that they continue to say that Bruen was wrongly decided. But since the conviction was upheld under the statute and it was not held unconstitutional, they agreed narrowly on the ground that the court got this particular case right. But although all three said that they continue to think that Bruen was wrongly decided and that judges ought to be able to basically policy analysis your Second Amendment rights away. The six conservative justices rebuffed that. They said, nope, Heller, McDonald, Bruen, that's the law of the land, and it will continue to be the law of the land. We are firmly entrenching the Bruen analysis with this case here under Rahimi. We're not saying that Bruen was wrong. We're saying it was right. We're not saying that McDonald or Heller were wrong or off balance in any way. We're saying that they were right. That's all good news because all of those cases were good generally for the Second Amendment community. Is there anything in Rahimi that might be considered helpful for the various arms ban cases that the National Association for Gun Rights is pursuing around the country? And the answer to that is yes. The court reiterated that any bearable arm is prima facie protected by the Second Amendment, and it is up to the government to show a historical analog that particular arm should not be protected by the Second Amendment. For example, it's dangerous and unusual. It's a weapon that would not be protected under the historical tradition of banning dangerous and unusual arms. Well, that's good news for us because the arms that have been banned are not dangerous and unusual. As a matter of fact, they're extremely common, owned by tens of millions of American citizens. So applying Bruen and now applying this language in Rahimi, the courts ought to be striking down these bans of arms in common use. How are the anti-Second Amendment lawyers going to try to use Rahimi? Well, they're going to say, this is not speculation, it's an utter certainty, that Rahimi says any analogy is good enough, that any regulation back from the founding era is good enough, that, yeah, there were regulations in the founding era and there were regulations now, therefore they're all analogous. And of course, that's not different from what they've already been saying in all of these cases. And they're going to continue to say it. And they're going to say that Rahimi gives them more ammunition to say that. But they'll be wrong. Rahimi does not say that every regulation is good enough from the founding era. Rahimi simply reiterates the Bruen standard on which regulations are sufficiently analogous. It has to be relevantly similar in why it was passed as a regulation in the founding era, and the burden it imposes has to be relevantly similar. And in this case, it said why was relevantly similar because it was trying to disarm dangerous people. And it said that the burden of temporary disarmament, keyword there is temporary, the 2-year disarmament in particular in Rahimi was temporary, was analogous to the surety laws, which were temporary. And so the court said, yep, it's at a given level of generality, those laws are analogous. It did not say anything goes. But you can be sure that the other side is going to say that anything goes. And so what's the bottom line with Rahimi? As I mentioned at the outset, we were hoping that the court would use Rahimi to clarify a lot of the issues that are outstanding from Bruen. But the court said, no, we're not going to do that. We are a court that under Article 3 decides cases and controversies. We do not decide things that are not in front of us right now. And so we're not going to reach out and decide all of these cases that are not in front of us. Now, we had hoped that they would actually, while not actually deciding those particular cases, clarify the law sufficiently so that it would be helpful in those particular cases. It didn't even do that for the most part. So Rahimi is out. We expected this decision. It does not hurt the Second Amendment community, and that's the good news. The even better news is it reiterated and did not retreat 1 inch from Heller, McDonald, and Bruen. And so the Second Amendment is in just as firm a footing today as it was yesterday. But there are certain things that the other side is going to do. They're going to go out and start pounding the drums for more regulation. They're going to say that Rahimi allows more regulation. It doesn't, but they're going to say that anyway. And the best way, and it has always been the best way, frankly, to counter that is to prohibit it from happening in the first place. Get involved in the democratic process. Support Second Amendment organizations like the National Association for Gun Rights, and get involved in the process. It's an ounce of prevention is worth a pound of cure. That's a tried old saying, but it's actually true, and it's true in the Second Amendment context as well. Not allowing a Second Amendment infraction to be passed in the first instance, is far better than trying to fight it back after it's passed. And we have seen Second Amendment advocates around the country rise up and beat back these infractions on Second Amendment rights, and that needs to continue to happen. In the meantime, if you do want to find out how to get involved or become more involved or to donate to a cause so that others can be equipped to be involved, consider going to gunrights.org and finding out tools for effective Second Amendment advocacy, and get involved in the fight to maintain your constitutional rights. The good news, the Second Amendment continues to stand after Rahimi.